In the matter of Bani Alam Mazid versus the State of Assam, Supreme Court allowed the criminal appeal and set aside the judgment and order of High Court, as well as that of Session Court, acquitting the appellant of charges levelled against him. Court held that we are of the view that none of the circumstances put forth by the prosecution to prove guilt of the appellant can be said to have been proved, not to speak of proving the complete chain of circumstances to dispel any hypothesis of innocence of the appellant. When prosecution failed to prove each of the circumstances against the appellant, the courts below were not justified in convicting the appellant. The criminal appeal by special leave was directed against judgment and order of Guwahati High Court dismissing criminal appeal filed by the appellant. Appellant was sentenced to suffer rigorous imprisonment for 5 years along with fine for 3,000 rupees with a default stipulation for offence under section 366A of IPC. For offence under section 201 IPC, he was sentenced to undergo rigorous imprisonment of 5 years along with fine of 3,000 again with a default stipulation. Appellant was also sentenced to undergo rigorous imprisonment for life and to pay fine of 3,000 with default stipulation of offence under 302 IPC. Prosecution case was that on 26/8/2003 at about 2 p.m. Amjad Ali lodged FIR before Hajo police station stating that on 22/8/2003 at about 3:30 p.m. appellant along with Muhammad Jahangir Ali had kidnapped his minor daughter Marjina Begum of 16 years. The first informant alleged that his daughter had taken away rupees 60,000 in cash from his house. He stated that though there was search for the girl, she could not be traced out. It was further mentioned that one Aklima Bibi, mother of appellant Bani Alam Majid, and one Farid Ali, husband of elder sister of appellant, came and told the first informant that the appellant had kidnapped his daughter and kept her at Mukalmuba with the intention of marrying her. First informant stated that two persons had assured him that their marriage would be arranged and requested him and his family members not to lodge any complaint before police. However, as there was no trace of missing girl for about 4 days, FIR was lodged. Appellant and co-accused Jahangir Ali were arrested. In course of investigation, dead body of the victim girl was found. At conclusion of investigation, charge sheet was submitted against both accused under section 366A 302 201 34 IPC. Learned counsel submitted that appellant had no reason or motive to cause the death of the girl. It had come on record that appellant and victim girl were in a romantic relationship and she had gone with appellant on her own volition. Even mother and brother-in-law of appellant were reported and father of victim girl that two of them would get married. Therefore, there cannot be conceivable reason or motive for the appellant to commit murder of the victim girl. He submitted that in case of circumstantial evidence, motive plays a very important role and its important link to complete the chain of circumstances. In its absence, chain of circumstances is not complete, in which case guilt of the accused cannot be said to be proved beyond reasonable doubt. In support of this contention, appellant referred to decision of Nandu Singh versus State of Madhya Pradesh. This was a case where conviction is based on circumstantial evidence. In recent decision of court in Ramuappa Mahapatar versus State of Maharashtra, court dealt with limitations of extrajudicial confession, which is one of the instances of circumstantial evidence. In this context, court, following the consistent line of judicial precedents, held that circumstantial evidence is not direct to the point in issue but consists of evidence of other facts which are closely associated with the fact in issue taken together. They form a chain of circumstances from which existent principal fact can be legally inferred or presumed. The chain must be complete, and each fact forming part of the chain must be proved. Where a case rests on circumstantial evidence, inference of guilt can be justified only when incriminating facts and circumstances are found to be incompatible with innocence of accused or the guilt of other person. When one of three circumstances was disbelieved and discarded by the High Court, then chain of circumstantial evidence could not have been held to be complete and proved, and on that basis to hold the accused guilty of offense. Each and every circumstance forming chain of circumstantial evidence has to be proved. There was considerable time gap between appellant and deceased were last seen together alive and recovery of the dead body. Therefore, it cannot be said with any degree of certainty that it was the appellant alone who had committed the offense. What Section 26 of Evidence Act says is that no confession made by any person when he is in custody of police officer shall be proved as against such person unless it is made in the immediate presence of the magistrate. This is exception to absolute bar of 25 section, which declares that no confession made to police officer shall be proved as against person accused of offense. Section 27 provides that when any fact is deposed as to be discovered in consequence of information received from a person accused of any offense in custody of a police officer, so much of such information, whether it amounts to confession as relates distinctly to the fact thereby discovered, may be proved. Discovery of fact arises by reason that the information given by the accused exhibited the knowledge or mental awareness of the informant to its existence at particular place, which includes discovery of object, place from which it's discovered, and knowledge of the accused to its existence. None of witnesses stated that they were present at the place from where dead body was recovered by police on being shown the accused person. They had only seen dead body in police station. Circumstances leading to discovery cannot be said to have been proved beyond all reasonable doubt against appellant. If that be position, not only the chain of circumstantial evidence is not complete, all the circumstances put forth by the prosecution to prove the guilt of the appellant cannot be accepted as having been proved as valid pieces of evidence. Therefore, the appellant deserves to be given benefit of doubt and is entitled to acquittal on this count. There is one glaring lacuna in the prosecution case that the court highlighted. It had come on record that evidence of the father and mother, that appellant's mother, Aklima, and brother-in-law Farid had told them that they need not worry about their daughter and they would arrange marriage of daughter with the appellant. According to the prosecution witness, Farid had told them he would bring the girl and arrange marriage and appellant, but these two persons were not examined by police and presented before the court. If their version is to be believed, both mother and brother-in-law of appellant knew about whereabouts of deceased girl. They therefore were material witnesses. Non-examination of material witnesses has dented the case of the prosecution. It had come on record that appellant and deceased were in love, and mother of the appellant, along with brother-in-law, father of the deceased, they would arrange the marriage. Therefore, there could not have been any motive for the appellant to cause the death of that girl. Postmortem report also ruled out sexual activity of the deceased. This, coupled with the fact that there was no recovery of cash allegedly taken away by the deceased from her residence, makes the prosecution narrative more suspect. In Anwar Ali versus State of Himachal Pradesh Supreme Court, after referring to previous decisions, observed that in case where direct evidence of eyewitness is available, motive loses its importance. But absence of motive in case depending on circumstantial evidence is a factor that weighs in favor of the accused. The court in Shivaji Chintappa Patil versus State of Maharashtra observed that in case of circumstantial evidence, motive plays important link to complete chain of circumstances. And the court in Nandu Singh case summed up the legal position that if the case is based on circumstantial evidence, motive assumes great significance. It is not as if motive alone becomes the crucial link in the case to be established by the prosecution, and that in its absence, the case of the prosecution has to be discarded. But at the same time, complete absence of motive assumes a different complexion, and such absence definitely weighs in favor of the accused.